On January 12, 2010, Haiti experienced a tragedy that was quite beyond belief. Haiti is in such devastation and there exists such extraordinary humanitarian crisis that Haitian nationals who were in the United States at the time the earthquake hit are unable to return to Haiti safely. And in fact, there is no infrastructure in place for Haiti to even process the return of Haitian nationals back into the country. In 1990, Congress passed a law addressing the humanitarian need for temporary protected status, or TPS, for foreign nationals in devastating situations exactly like the one caused by the January 12th earthquake. Under this law, the Secretary of the Department of Homeland Security is authorized to designate a foreign state for TPS upon finding that such state is experiencing ongoing armed conflict, an environmental disaster, or extraordinary and temporary conditions. As Ira Kurzban, a nationally renowned immigration lawyer, scholar, and our friend, eloquently noted, the law says that we may give temporary protected status to people facing earthquakes, armed conflict, and devastating natural disasters. Since 2004, Haiti has experienced all three. We have given TPS to many countries since this law was enacted in 1990, and never in the history of TPS have we turned down TPS to a country who has faced all three of the enumerated conditions. Currently, El Salvador, Honduras, Nicaragua, Somalia, and Sudan are all designated TPS countries. TPS for Haitian nationals has been granted for 18 months from January 12, 2010 through July 12, 2011 for Haitian nationals. TPS is not amnesty and is not designed to provide a way for illegal and undocumented aliens to gain permanent residency in the U.S. TPS is a humanitarian measure of a temporary nature. Now, when has the U.S. government said that Haitians may apply for TPS? Haitians may apply for TPS from January 21, 2010 through July 19, 2010. This is a 180-day registration period. Now, who may apply for TPS? Haitian nationals who have continuously resided in the United States since January 12, 2010, and who have been continuously physically present in the United States since the TPS designation was published on January 21, 2010. What is the difference between continuously resided and continuously physically present? Well, if you were in some kind of legal or non-immigrant status on or before January 12, 2010, you may have been granted the right to travel in and out of the United States while still maintaining your legal status. A travel document enabling this kind of travel in and out of the United States is known as advance parole. So, for example, if you are traveling on advance parole on January 12, 2010, you are not physically present in the United States. However, as long as you can prove you resided in the United States at that time and you are a Haitian national, you are eligible for TPS. However, you must also prove you have been continuously physically present in the U.S. since January 21, 2010. This means that if you resided in the U.S. before January 12, 2010, but were traveling at the time, you must have returned to the U.S. by January 21, 2010, and must have physically remained in the United States since that time in order to qualify for TPS. Now, what if you are an illegal Haitian national? Well, even if you did not have any status on or before January 12, 2010, meaning you had entered the United States without inspection or were illegal, as long as you are a Haitian national and have been continuously present in the United States since January 21, 2010, and you have continuously resided in the United States since January 12, 2010, you are eligible for TPS. However, you should note that once TPS is expired, you go back to being an illegal alien and possibly subject to deportation and removal. So, in effect, by applying for TPS, you are alerting the government that you are illegal and where they can find you once TPS is expired. What if you are currently in deportation proceedings? TPS stops all deportation proceedings for the designated period of 18 months. And who is not able to apply for TPS? Well, if you have been convicted of any felony in the United States, you will not be eligible for TPS. If you have a final order of removal, you may need to take additional steps before you can apply for TPS. You should contact a qualified immigration attorney. If you have been convicted of 2 or more misdemeanors in the United States, you are generally not eligible for TPS. However, if 2 misdemeanors are traffic-related offenses, or you entered a pretrial diversion program, or a deferred prosecution, or you have some kind of withheld adjudication, you should speak to a qualified immigration attorney, because what the state may define as a conviction may not be a conviction under federal immigration law, and vice versa. Now, if you have been convicted of a crime involving moral turpitude, you may also be ineligible for TPS. This, unfortunately, is a rather complex area of immigration law. There's a general list of such crimes on strongvisa.com, but if you have a question about a conviction for a crime that may be within the definition of crimes involving moral turpitude, you should also speak with a qualified immigration attorney. If you have been convicted of any drug offense, you will not be eligible to apply for TPS. There is one exception, however, and that is for a single conviction for possession of marijuana 30 grams or less. There are many other grounds of inadmissibility that may prevent a foreign national from obtaining status in the United States. In the TPS situation, some apply, some don't apply, and some may be waivable. If you have a question about grounds of inadmissibility, again, I would recommend that you speak with a qualified immigration attorney. But more information on grounds of inadmissibility can be found on our website, strongvisa.com. Now, how does one actually apply for TPS? Well, first of all, you will be applying to the Department of Homeland Security, U.S. Citizenship and Immigration Services, otherwise known as USCIS. And here are some helpful websites to get you started: uscis.gov, uscis.gov/blog, and our website, strongvisa.com. You may also call the USCIS National Customer Service Center at 1-800-375-5283.